Good morning, everyone. Today is Monday, April 20th, 2020. It's approximately 10:06 a.m. Thank you again for joining us for our daily podcast. We have the Family Law Matters legal panel with us. I'm going to give them an opportunity to introduce themselves, but first I want to remind the participants that as you join the meeting, please make sure that you are muted, and if you have any questions, feel free to send them to us either via email or via the chat room in Zoom. So with that said, Gina, tell us a little bit about yourself.
Sure. I'm Gina Famularo, and I'm one of the partners at Family Law Matters with you, Bishoy. And I've been an attorney for 22 years, going on 23, all in the family law realm. I've practiced both in Orange County and in Riverside.
Thank you, Gina. Christy?
Good morning, everyone. My name is Christy Bergamo. I'm a senior attorney here at Family Law Matters. I've been practicing 17 years. I'm also an instructor at University of California, Riverside in the paralegal program, and I have been certified to be minors counsel in the courts in Southern California.
Thank you, Christy. Colleen?
Good morning, everyone. My name is Colleen Robinson. I'm a family law attorney here at Family Law Matters. I've been practicing now for 10 years, mostly in San Diego County and Riverside County, but I've appeared all over Southern California, and I've practiced mostly, like 97% of my practice has been in family law.
Thank you, Colleen. And I am Bishoy Shahada. I'm also an attorney. Been an attorney for a little over 2.5 years now, and family law is all I know. So, Gina, we're talking about guardianships today. What is a guardianship?
Sure. A guardianship is an action by non-parents to receive custody of a child under the age of 18.
So who does it apply to then?
Sure. It applies to typically, the typical guardianship situation is where a child has been left in the care of a non-parent. The common scenario would be a grandparent or an aunt or an uncle. So the parents, for whatever reason, are unable to take care of the child or children, and the child is not in the foster care system. That is a completely separate process. A guardianship is a private process that's started by people because they need custody rights for a child that is not their biological child.
So do they have to be blood related?
No, they don't have to be blood related, but they need to have some sort of connection to the child. I have seen caretakers get guardianship of children. It's more of a temporary process as opposed to, let's say, an adoption. So an adoption would create a permanent bond between the child and this non-parent so that it becomes a parent-child bond forever. A guardianship, what it does is it creates the right to make decisions for the child as though you are the parent. You can make right to health, welfare, and safety of the child.
So how long does it take to get a guardianship?
That's a great question. It is quite a process. It starts with a stack of papers that is about 2 inches high, and then it goes on into an investigation, and then it goes on to a hearing. All of those things are mandatory before you have your guardianship granted. So in a scheme of things, let's say on the short end, it's about 3 months. On the longer side, it's about 12 months.
And how long can the guardianship orders last for?
Sure, they can be temporary guardianship orders, which could last for a matter of days or weeks. And they could span all the way to when the child reaches the age of majority, which is once the child is 18.
So you mentioned that there's a 2-inch stack of paperwork that needs to be filed in the beginning. So how difficult is the process then?
The process is incredibly difficult, which is kind of surprising when you think about it, because this is for people, essentially good Samaritans, people who have no ties to this child that are trying to step up and do the right thing and care for a child that's not theirs. But the process is very technical in nature. There's a lot of boxes to check, and if they're not checked properly, it could mean that the guardianship is denied or not even filed. Also, once you get to court, it remains to be technical. There's actually a probate attorney that would review the documents to make sure that they're done correctly. And you have to make sure, what we call in the business, you clear the probate notes, meaning that any technical difficulties or shortcomings are corrected. In addition to that, there's also the grounds for which you apply are also difficult. So you have to make sure that the declaration is done properly, that the paperwork is filed in the right spot, that the proper paperwork is filled out, that there's an investigation, that the proper documents are provided to the court so that the investigation can be completed properly. So there's a whole bunch of steps to go through before the guardianship process is granted.
With all of that scrutiny, can someone apply for a guardianship if they have a criminal background or criminal history?
That's another great question, and it depends. It depends, first off, how long ago the conviction was, whether it was a felony or a misdemeanor, and of course what it was for. Certainly if it's something that has to do with endangering children, it's going to be very hard to justify giving a child to that non-parent. However, if it's something like maybe financial crimes or a DUI and time has gone by, I don't see any reason why that can't be overcome.
What about some sort of bankruptcy? If the person asking for a guardianship has filed a bankruptcy, does that affect guardianship?
It's certainly one of the things that you're going to need to disclose when you have to fill out your character questionnaire. But as long as you can meet the basic needs of the children or child, there should be no problem. You're definitely going to need to disclose it, and you're going to need to show that you have the financial means to take care of the child. But other than that, you should be fine. Of course, if you have the help of counsel, we can help explain away the bankruptcy or the criminal act probably a little bit better than the non-attorney. So if you have these types of problems, it's probably all the more reason why you want to hire counsel.
Thank you, Gina. And then the final question, the most common question we get is, how much does a guardianship cost?
Sure. It depends if you go through an attorney or not. I would definitely recommend you don't go try to do this yourself. Again, it's an incredibly technical procedure to get a guardianship. There is a filing fee. There is money that's going to be paid to the court, and it is quite expensive. It pays for what is an investigation. Somebody actually has to come out to the home to investigate, and of course the county needs to be compensated. And then if you retain counsel, it's going to add to the cost again. So the cost of a guardianship is going to be significant. So you want to make sure that you do it right. You only do it if you're going to win, and you have the proper grounds to have it granted.
Thank you, Gina. Colleen, I know Gina talked briefly about the process, but can you walk us through the process from the minute someone walks into your door and is asking for a guardianship?
Sure. So first we have to ascertain or ask ourselves, do you need a temporary guardianship? So what is a temporary guardianship? A temporary guardianship, and I know Gina talked about it briefly, is kind of a stopgap or some temporary orders between when you file and then when you have a permanent guardianship hearing, at which point the court is going to have an investigation report completed, have more information at the permanent guardianship hearing. But if you're in a situation where the facts warrant you having immediate custody of the child, the court will set up a temporary guardianship hearing. So the tricky part is that the documents are virtually the same. It's a matter of checking certain boxes. So I've had a lot of clients who started the process and then realized they never asked for temporary guardianship, so they don't get it. So now you've got to wait the period of time until your next hearing date to get the orders that you need to enroll a child into school. And I think Christy's going to be talking about that, or taking them to the doctors or something along those lines. So we have to, that's the first question I always ask is, what's going on and do you need a temporary guardianship? Because that requires 2 sets of documents getting into the court and 2 different hearings. So one is preparing all of those forms. And then we also have to ask, who needs notice in this situation? There's a variety of people. Unlike a family law case where it's like the parents, here you've got to notify certain relatives of the child. It's not just the parents in this situation. So we have to do almost like a family tree and figure out who do we have to give service to, give notice to, who do we need to serve? We need their addresses. We need to be able to contact these people. And then if not, then there's a whole other process that we need to do to notify the court of the efforts that we've made to try to notify these people. Once we get all of our paperwork organized, we then submit it to the court. And then what is unique about the guardianship process, as Gina had mentioned, is that there's this other party between you and the judge, and that is the probate examiner. So it's this attorney that works for the court, and they have a lot of power, so to speak, because they're reviewing all of the documents and generating a report to the judge that the judge relies heavily upon as to whether all the boxes have been checked. And if a box hasn't been checked on their checklist, likelihood of your case going forward and being continued is very high. So it requires a different level of attention than a family court case, essentially, or that you need to be on top of in monitoring your case online through the probate department and looking for these probate notes, because if it's something you can fix, you've got to file documentation before your hearing so that your hearing isn't continued, because that's the last thing you want to happen. Most people in these situations, they need to get custody orders as soon as they can. So we get all the documents ready to go. We get them filed with the court. We serve the necessary people. We get our court dates, and then from there it kind of diverges. Are we going to a temporary guardianship? If not, if there is no temporary guardianship hearing, then we're preparing for the permanent guardianship hearing, and we've got an investigation that's going to be going on that works similarly, if anybody's been hearing any of our prior podcasts, to a mediation through the family court services or through CCRC. It's similar kind of, but it's much more thorough, and it's a different set of standards that the court will be looking at in the probate department. So we have to get that. There's also consent forms, if necessary, that we can get as well to prepare for the guardianship hearing. There's a lot involved, I should say.
So when the investigation takes place, do the investigators come to the guardians or the proposed guardian's home?
They can. I've seen them do it both ways, that either it's at their office or they come to the home, and it's completely up to that investigator. So if they're making that suggestion, I know that a lot of people are uncomfortable having a government employee into their home, but you need to comply. I mean, you don't want to seem like that you're resisting or being difficult or anything along those lines. They're there for a reason. There's certain things that they're looking for to make sure that the home is safe, that you have utilities, the lights are on, there's water, there's food in your fridge, and an adequate space for the child. So there's very important information that they're trying to obtain to tell that to the court. They're there to try to help you, so to speak, in order to get the information the judge needs to make that final determination for the guardianship.
And what if the biological parents agree? Is the process the same?
The process, it certainly gets streamlined when you have consent. There's consent forms that allows for that so that the parents can sign off on that, as well as other family members. And we try to do that very early on in the case, because it certainly is very helpful. So if everybody consents, normally the judge isn't going to get in the way of doing that. So that's very helpful.
Okay, and what about the child's consent?
Well, the child's consent is required if the child's over the age of 12. Okay. And they're going to be interviewed by the investigator as well, so they'll be giving a lot of information to that investigator.
And now let's talk about the other side, where the biological parents don't agree, or at least one of the biological parents doesn't agree.
Well, so the temporary guardianship hearing, it depends on what happens or what the recommendations are, but certainly if a parent doesn't agree and you have a very favorable investigative report, that's going to be weighed upon heavily for the judge. Otherwise, you could be in a situation where you're looking to go to trial, depending on what the circumstances are. So the court at your permanent guardianship hearing could very well set your case up for trial.
So, and then I guess the only other question that I usually get is, what if we can't find the parents? So it's not that they agree or don't agree, we just can't find them.
That happens quite frequently. And so, as I was mentioning before, there's still due process. There's still an effort that you have to make. There is a declaration that you file with the court showing all the efforts that you have made to locate the parents. So looking up white pages online, or looking into social media accounts, and you have to show all of the efforts that you've made to locate people, and then you can ask the court to discharge that requirement of giving notice to that certain person, but the judge needs to make that order.
Perfect. Thank you, Colleen. Christy, I want to bring you in on this conversation. So let's assume that the guardianship order has been granted. Can the new guardians now get that child or children on their health insurance plan?
Absolutely. That's pretty much what it's designed for. But I want to make a comment before I start my answers. This is probably one of my favorite areas of the law. And there's a judge in Riverside that says at the opening of every day that there is a special place in heaven for people who assume this role. Because what Gina pointed out, this is a labor of love. This is stepping into the role to provide for a child that is not yours. So I just love this area of the law. It's really rewarding for me to be able to do these. With that said, yes, they can get the child on their insurance. Those are the types of rights that are afforded to the guardian when the guardianship issues.
And what about support, like child support? Can the court make orders that biological parents have to pay child support?
Absolutely, B. They still have a duty to support their child, but usually in these circumstances, there's a reason why the parent can't provide for the child. So trying to get those orders is absolutely a possibility, but whether or not there's any money there is a totally different issue. There's also government programs. There's state programs. There's one program called the Kinship Guardianship Assistance Payment Program, KINGAP for short. That is an area that I suggest most guardians look to obtain some sort of financial assistance for this child.
And what if the guardians, after getting the order, want to move out of state? What do they have to do at this point?
You have to be very careful about doing those things. Usually 99.9% of the time, the order is that you have to obtain permission to move. So it is a matter of filing an additional petition to ask the court to move. And obviously that's going to require a court appearance. You have to explain to the court why you want to move, what's the reason, all of those things, but you just don't just get up and move. I've seen guardians sanctioned by the court for moving without notice. The guardian also has to file an updated notice. They have to show grades, the child's grades, how the child's doing, and they have to file that every year. And I've been in court so often when guardians have failed to do that, and there are sanctions as a result. It could, in fact, terminate the guardianship.
And you mentioned the grades, so I take it that the guardians can enroll the child in school then?
Absolutely. Again, these are the kinds of rights that are bestowed upon the guardian. This is why they get a guardianship, so they can do these types of things.
And what about child counseling?
Counseling is another area. And, a lot of times during this process, obviously the child probably will have some issues regarding, not being able to be around their parents. So absolutely, they have the right to seek counseling for them, for sure.
Let's talk about the biological parents. What if after the guardianship, the biological parents get their act together, they're now fit, and let's take it in gradual steps. So let's say they're now asking for a visitation. How does that play out?
Well, absolutely. They are entitled to, and a lot of times during the guardianship proceeding, Colleen mentioned CCRC. That is sometimes ordered in a guardianship when the parents want visitation. So say, for instance, they object and the court feels like the case is strong enough to issue the guardianship, but the child has a connection to the parents, or they'll send them to CCRC, which is custody mediation, and they'll try and work out a schedule there. And if they can't, then that will be something that the court can order. Subsequently, I always tell my guardians that, you know, the parents, if they can have visitation, should have visitation with the child. This is not to obtain the upper hand. This is merely to give the child stability. So they should be open to that.
And now, if the biological parents are fit and all parties agree that, you know, they should terminate the guardianship at this point, how does that work out?
Well, there's a petition to terminate the guardianship that has to be filed, I think, just in order to be safe. Everybody's got to be on the same page, and you want to do this through the legal process. I've seen a lot of times when the understanding was that, you know, the parents were fit now, so the child was going to go back, but for some reason, the guardians come in and assert their authority again for some reason. So you really want to go through the court process and petition and just agree to terminate the guardianship. I've also had where, and this I think comes up more often than an agreement. Usually the agreement is not the norm fee. Usually it's that the parents feel that they're fit to have their child or children back and the guardians don't agree. And under that situation, the parents need to file a petition to terminate the guardianship. And usually that comes with a court hearing and or trial on the issue of whether or not the parents should get the child back. And I've most often in those situations, the court orders me to supply some sort of legal theory or legal points and authorities regarding as to why or why not the guardianship should exist or not exist. So these are very technical legal issues. There's standards here that apply. Sometimes, even if the parents are fit, the court may look to the stability of the child and weigh those. So this is not an easy thing to accomplish on your own. I've seen people who represent themselves in these processes and don't know how they work, and they're not successful. So you really need an attorney if there's a disagreement about whether or not the guardianship should still exist, because it is a difficult legal standard. It is not just, gee, I want my kids back. It is way more complicated than that.
So in your experience and based on your experience, can the guardianship orders be changed?
Yes, absolutely. They can be changed to reflect the current situation of the case. This is not a one size fits all at all. It's really complicated. So yes, but you need to go through the court process to do all this, is my opinion.
Thank you, Christy. Any final comments for our viewers?
No, just like I said, I mean, this is an area of the law that is really rewarding, but really, really complicated. It is not to be taken lightly. I think our entire panel has expressed the amount of paperwork and how particular this needs to be done. And I think the reason why is that the guardian is stepping in the place of a parent. So the court needs to be very, very sure before they play with the constitutional right of a parent. So that's why it's so technical. That's why it's so difficult, because the court needs to be absolutely sure that this is the best idea for the child. So that's why it's so complicated. And again, I've been in court where I've seen people who are representing themselves and the judge is like, your paperwork's wrong. I'm continuing out 3 months. for you to do that. And every time they come back, it's like the revolving door of not being able to get what they need and get the orders and to be, done with that, with the process. So I implore you to not do this alone. It is very difficult. So, but very rewarding for me in terms of an area of practice that I just really enjoy doing.
Thank you, Christy. Colleen, anything to add to that?
Yeah, it just kind of dovetailing off of Christy is that it can be a very unforgiving process if there's mistakes in your paperwork, which I've seen proposed guardians and they're bringing the children and they're needing orders to enroll kids into school, and the judge can't give them any legal advice. They can't do anything other than continue the hearing and suggest either going to the facilitator's office, or I think they have like some sort of helplines, or to get an attorney. And also with people trying to make agreements amongst themselves, it's a very judicially involved process. So the judge needs to make the final call by signing off on an agreement. And I've seen it several times being in the probate department of guardians getting sanctioned for not filing the necessary paperwork to either terminate a guardianship, though they believed that they were acting on good faith and that they believed that the parents were able to step up and take care of their kids. Or why they moved, they told the parents and the parents were okay with that. But the courts, again, because it's so judicially monitored, for the reasons Christy stated, because you're taking the constitutional right away from parents, they need to be involved. So I don't know, you can't forget that. And so that's why I just think this is something, again, that you don't want to go into this by yourself. You definitely need some help from a lawyer.
Thank you, Colleen. Gina, any final comments?
Yes, a guardianship is not a vehicle to take a child away from parents. A guardianship is not a vehicle to protect abused or neglected children. A guardianship is a very narrow proceeding, typically for non-parents who are already caring for a child and need to provide the child with stability and continuity. What it does for those non-parents is it allows them to step into the shoes of the parent and to provide the child with the needed help, medical care, educational assistance, enrolling in school, whatever that child needs, health, safety, and welfare, it allows the non-parent to do.
Thank you, Gina. And I want to take this opportunity to thank the legal panel for taking the time out of the day to share this knowledge with us. I do want to remind the participants that this recording will be posted on all of our social media sites, Facebook, our YouTube page, and our website. If you have any questions, please feel free to send them to us. If you need a consultation, you can schedule one in one of three ways. You can visit our website and request a consultation there. Our website is www.temeculadivorce.com. You can call us at 951-587-0505. Or the third option is you can email us at info@temeculadivorce.com. Once again, thank you, legal panel, and God bless us all.
God bless.